E-Discovery, a presentation by Carrie Packer, Eric Seckinger, and Carol Ann Palmieri.
What is e-discovery? Electronic discovery is the electronic aspect of identifying, collecting, and producing electronically stored information, or ESI, in response to a request for production in a lawsuit or investigation. ESI includes, but is not limited to, emails, documents, presentations, databases, voicemail, audio and video files, social media, and websites. It can include any sort of document or other information that might be useful to prove a plaintiff's or defendant's case in a civil action. The technology changes rapidly, making a complete list impossible. What are the advantages of using e-discovery? Well, electronic discovery can help realize significant litigation efficiencies. Through automated methods, some forms of electronic documents and electronic media can be searched quickly and fairly accurately. For some electronic documents, software may be capable of searching through far more documents than human beings could ever review manually. Metadata and system data provide additional information about electronic documents and actions of computer users that are not available with traditional paper discovery. What are the disadvantages of using e-discovery? Electronic documents can be easily damaged or altered without any human intent, intervention, or even knowledge. The volume and dispersion of electronic documents can make them difficult to find. The complexity of dealing with unfamiliar technology may necessitate calling in computer forensic experts to help with electronic discovery. Electronic discovery can increase discovery costs many times over. Why is e-discovery valuable in litigation? There are no longer paper trails that establish who did what and when. Electronic evidence is providing the clues to understanding what actually happened. Electronic documents present unique opportunities for obtaining information. And electronic documents can contain additional information that paper documents cannot provide, including metadata and system data. Furthermore, e-discovery plays such a valuable role because most employees rely on computers for productivity, communications, and leisure. The combination of email and poor judgment represents a valuable source of information for employees and employers alike. Leveraging computer forensics is beneficial to find hard evidence against the accused, but can also quite often be able to disprove allegations.
So what is the big deal with e-discovery? Well, in 1978, before e-discovery, several television networks and the Justice Department sued CBS for antitrust violations. CBS produced over 6 million documents in the discovery process. The discovery process ended up costing over $2.2 million. Most of this money went to the salaries of paralegals and lawyers who were tasked with reading the documents. Today, with email, instant messaging, text messages, and other electronic communication, many more documents are produced by much smaller companies and would cost them a great deal if discovery were to become necessary. So the question becomes, how do we make it easier? There are several types of software now available to make e-discovery much more simple and convenient, as well as make it much more efficient for the attorneys and paralegals tasked with actually going through all this discovery. There are three major types of software. The first is file archiving software, which is particularly useful for email and instant messaging. The next type is file retrieval software, and finally file searching software, which we will discuss all of these. What does file archiving software do? Due to state and federal regulations, many forms of electronic communication must be kept for a certain amount of time before they can be deleted. Archiving software keeps companies in compliance with these e-discovery mandates. What it does is store copies of files, emails, instant messages, and more as they are created in a separate archive. It then creates databases that can be searched in case these files need to be retrieved. The greatest thing that it does, however, is that it also deletes these files as they are no longer required to be kept for the e-discovery mandates, thereby creating more space in the file servers for storage. The next type of software we'll be discussing is file retrieval software. File retrieval software is used when you are trying to collect files from the other party's computers. You can do this by sending the program to them, and it will download files within the predetermined parameters you set into the program. Certain types of these programs can be used without ever actually traveling to the computer you're trying to download them from. This can be accomplished by downloading the program onto a portable hard drive, sending the hard drive to the other party, who would then connect it to the computer required for download. The program would then download the files onto this portable hard drive, which can then be mailed back to your office. The advantage of a program such as this is that it preserves the fragile metadata and timestamps that are embedded in these files. One example of a program that does this is One Click Collect by Pinpoint Labs, which costs approximately $1,500 per year to use. Finally, we'll be discussing what file searching software does. This is used to find the information you're looking for much more quickly and efficiently than reading all of the documents that you've collected. What these programs do is scan all of the documents you've collected and create an index that can be searched. This index can be searched by a host of different methods, such as Boolean, fuzzy, and many more. This saves time because you don't have to read all of the documents you collect and need far less people to do it. One program that does this is known as DT Search Desktop. It costs approximately $200 per seat. The biggest advantage of all of these programs is that they can save the client money by saving time and effort in trying to find the kind of documents you need to make your case.
As the legal community works diligently to master the aspects of e-discovery, it could be argued that these changes in the discovery process have had the greatest impact on the role of the paralegal. E-discovery has not only transformed the day-to-day workflow for paralegals, but additionally has created new job opportunities for them within the law firm. As a result, it has unveiled new career paths which formerly did not exist. Paralegals have functioned as the case managers for the document collection and management phase of a litigation, and this expectation is no different with e-discovery. Once attorneys have wrestled with discovery motions and the dust finally settles, paralegals are then faced with the challenge of figuring out just what to do with that mountain of data. During e-discovery, all documents must go through the same processes as in the paper world, but the goal for attorneys in e-discovery remains the same: to quickly locate any necessary documents and ensure that no important information is overlooked. At first glance, this task may seem overwhelming, but with new challenges come new opportunities for paralegals to make themselves invaluable to their firms. Changes in case management procedures for e-discovery have resulted in new career opportunities for paralegals as they master new skill sets. In the past, although some law firms had specialist roles for their senior paralegals, not many, if any, had positions entitled litigation specialists. If litigation paralegals wanted other career choices, there was only the management option or litigation support. Either way, these choices typically meant giving up the case management side of litigation. Today, it should be noted that these new job responsibilities also bring with them a greater potential for salaries. So what are these new career options for paralegals? Well, a litigation paralegal can handle all aspects of case management, which may or may not include e-discovery. As an e-discovery paralegal, exposure to e-discovery increases significantly from the litigation paralegal because it is this component of the position that is the primary job responsibility. As a litigation support person within a firm, this person's only involvement is with the technical aspect of e-discovery. And finally, there's the e-discovery manager. Typically, this person had been an attorney. However, many paralegals are now pursuing this opportunity because the salary potential is significantly greater. As an e-discovery manager, one would oversee the technical and substantive end of the e-discovery process on one case or even an entire department, dependent upon the particular law firm. This poses an interesting question. As the world of e-discovery unfolds, presenting new challenges, and technology emerges to overcome these hurdles, how will paralegals adapt to convert these obstacles into opportunities?